Ladies and gentlemen, welcome aboard the Wright Flyer. Today's flight is piloted by Randy Wright, who is joined by his first officer Jeremy Grapenton. We know you have a choice when it comes to your radio listening pleasure, and would like to thank you for choosing to fly with the Wright Flyer. Ground traffic control has moved us to the departure lane, so please be seated, fasten your seatbelts, and ensure that all tray tables are stowed in the upright and locked position. We will be taking off shortly, and once again, we'd like to thank you for choosing to fly the Wright Flyer. Now sit back, relax, and enjoy the show as we soar above the friendly airwaves in comfort and style.
Ladies and gentlemen, welcome aboard the Wright Flyer. This is your captain speaking, and I would like to take this opportunity to personally welcome you to this constitutional special edition of our state-of-the-art radio program. We know you have a choice when it comes to your radio listening pleasure, and would like to thank you for choosing to fly the Wright Flyer. What's more, we're confident that no other radio program or venue will fly you over the friendly airwaves in as much comfort and style, nor leave you with an indelible yet pure sense of enlightenment quite like we can here at the Wright Flyer. Now that you're aboard, please be seated, fasten your seatbelts, kick back, relax, and enjoy the show. We've taxied to the departure lane and are awaiting takeoff clearance from air traffic control. While they go through that mindless, bureaucratic red tape and regimentation, my first officer, Jeremy Grapenton, and I shall delve into the pre-flight checklist because there is a lot of news and information to get to before we may indulge you with your in-flight entertainment. Well, folks, thus far on these constitutional special editions, we've covered some of those aspects of the United States Constitution which are least known and least utilized, primarily the privileges and immunities clauses, the preamble to the Bill of Rights, and, of course, the Third Amendment to the United States Constitution. As Jeremy and I have frequently reiterated here on previous episodes of the Wright Flyer, the most important service that we can render to you, our listening passengers and audience, is to provide you with the building blocks to gain a fluent and working knowledge and understanding of our shared Constitution. And part of that requires that we also investigate and examine the better-known aspects of the United States Constitution as well. Therefore, on today's program, we are going to be shifting gears a little bit and focusing on one of the best-known, most frequently utilized aspects of the United States Constitution, that being the Fourth Amendment guarantee against unreasonable searches and seizures in general, and the warrant requirement in particular. Despite the fact that this is one of the best known and most frequently utilized fundamental and unalienable rights within the United States Constitution, it nonetheless is one of the most endangered rights due to the way that the courts have been handling the issue and adjudicating the issue over the course of our long and illustrious history. And to fully understand why the Founding Fathers gave such importance and weight to this fundamental and unalienable right, it's important to delve a little bit into the history of the Fourth Amendment. Why do we even have the Fourth Amendment? It's easy to lose sight of the fact that this is such a monumental and revolutionary development in the criminal justice systems of the world, because we have taken it for granted for so long. But going back to the War for American Independence, we find that the notion of a general warrant, which essentially gives the government carte blanche to search any premises for any reason and to seize or detain any person or anything for any reason, is partly what really drove the impetus of including the Fourth Amendment within the Bill of Rights. In fact, not John Adams, but Samuel Adams and his patron, John Hancock, were both targeted by general warrants issued from the Crown when they were known to have been leading some of these quote-unquote dissident groups that had arisen before the revolution got into full swing. And this, of course, was all in addition to the strains that had developed at the end of the French and Indian War, as it's known here in the United States, or the 7 Years' War, as it was known in England. And the English, or to be more correct, the British Empire, didn't understand how the American outlook had begun to diverge from the identity of the mother country. England was still seeing the colonists as their property, if you will. But part of the problem was that the colonists were perceiving that they were not receiving actual representation, and it was again England or Britain saying that they were going to act upon this notion of virtual representation, claiming that the colonists had full representation even though they were not entitled to elect representatives in the Houses of Parliament in England. And when the colonists began to react to this, that is when we started to see more draconian general warrants being issued, because the British were wanting to secure their foothold in the New World. And that had detrimental impacts and waves in the New World, and that is what inspired the Founding Fathers to include the Fourth Amendment within the Bill of Rights. And of course, the Fourth Amendment is the most important aspect of our entire criminal justice system, because it is what guides and governs most of what disputes you see within the criminal justice system. The idea of having an exclusionary rule in evidence is rooted in the Fourth Amendment. Any tainted evidence, or what is known as fruit from the poisonous tree, cannot be entered into evidence, and that is all part of the Fourth Amendment, which also provides an emphasis on what the Founding Fathers thought were important: the right of the people to be secure in their persons, houses, papers, and effects. That was, again, something that was truly revolutionary.
Well, with the Fourth Amendment, it also ties directly into, just like all of the amendments do, to certain aspects of each other. The Fourth Amendment ties directly into the Due Process Clause of the Fifth Amendment. Because if an individual is accused of a crime, there has to be an investigatory process. This is where the warrants are issued to name a certain individual, to name specific places to which shall be searched, specific property that should be seized. All of that ties in and sets up the long haul for the due process to take place. You can't have a prosecutor say, well, this individual we're going to charge them with reckless endangerment or murder or any other crime, whether it's a simple civil infraction as a traffic ticket or a federal offense. There still has to be that warrant issued, sworn on oath or affirmation, that the information that is given in order for them to be able to search these things is done so with probable cause. Okay? Not suspicion, Not because somebody matches the description of another individual that may have done this, but there has to be probable cause. And with issuing the warrant, in a roundabout way, that actually justifies the probable cause. You have the probable cause, you find the information, okay, now you put it together, it's like a puzzle. You put everything together, it fits. Yes, the probable cause was justified because the warrant was executed properly. And the information, whether it's property, the individual, when you get the statements from them, so on and so forth, all of that ties in. And if there's any tear in that fabric whatsoever, it's like yanking on a loose thread. Okay? When you keep pulling on that loose thread, everything unravels. The Fourth Amendment could actually be argued as the glue that holds everything together with the due process and the criminal justice system at every step of the way. Because even in cases where things are appealed, most appeals are based on, well, this evidence was falsely obtained, or this evidence wasn't presented, this happened, so on and so forth. And it all seems to stem right back to the Fourth Amendment and that right of the individual.
And what is so important about the right of the individual with respect to the Fourth Amendment is that the Founding Fathers inherently understood that the right of the people to be secure in their person, houses, papers, and effects meant that their rights superseded the authority of the government. When you looked at how the Crown acted in the period of time leading up to the American War of Independence, they acted in an arbitrary and capricious manner. These so-called general warrants were issued and basically gave the troops of the Crown the authority to barge into any place they wanted, to seize any person they wanted, to do anything that they wanted, so long as they did it under the color of the authority of the Crown. And our Founding Fathers wanted to prevent that from happening in the fledgling federal government that they were creating with the United States Constitution, and the way they accomplished that is through the Fourth Amendment. What the warrant actually represents is the embodiment of proof that they actually had probable cause to suspect that the accused had actually committed the criminal offense of which he or she had been accused. That was a major departure from the sort of system that you had with the general warrants within the British system that predated our Republican system of government. And to take that a step further, part of the reason that you have the Sixth Amendment's right to face your accuser is also from the notion of the Star Chamber, that dreaded court in England that allowed the government to move forward with criminal charges in pure secrecy without letting the accused know. And again, that also ties into due process. Now, with the warrant requirement, the government is supposed to, by either oath or affirmation in the form of an affidavit, prove that they have probable cause. In other words, the warrant itself must be supported by probable cause in the form of oath or affirmation, and particularly describe the person, place, or things to either be searched or seized, meaning that the law enforcement officers and agencies cannot just willy-nilly move in to whatever house they would like to, or to gather whatever information they might like to just on a whim. The Founding Fathers strictly believed that our fundamental and unalienable rights were of such importance that they could not be easily taken away. In fact, the entire purpose of the warrant requirement and the requirements of probable cause to support it is to say that you can only have a fundamental and unalienable right taken away when it is proven, and truly proven, that you have somehow encroached upon the fundamental and unalienable rights of your fellow citizens. And that is the entire framework. It's like the flying buttress that supports the entire edifice of our criminal justice system, and therefore it is a central tenet of our criminal justice system. And that's why when you see things like the NSA snooping programs, the FISA court, all of these law enforcement agencies attempting to go around the Fourth Amendment warrant requirement, it should be a cause of concern for each and every decent, hard-working American citizen, because it means that they can now, as long as they are whittling away at it, move towards that same type of carte blanche that would be afforded to them with a general warrant. If you look at the exposed snooping programs, that's basically even worse than a general warrant, because they aren't even going through the judicially sanctioned process, even if it would be a farce, to gain a general warrant. Now, you have a bit of that with the FISA court, but these actual so-called metadata recording, all of these things like the prison program, reaching out into cyberspace and capturing as much data and private and personal information about the American citizens as they can, is even worse than the general warrant, because they just are doing it without any form of authority whatsoever. And the way they justify it is to claim that they are doing this for either national security or to keep the country safe, or you wouldn't have anything to say about it if you didn't have something to hide, and only the guilty have something to hide. So in that respect, they even go against the presumption of innocence until proven guilty. And so it is a major problem that we are facing, because it is attempting to undermine the very foundation of our criminal justice system, as Jeremy and I have both stated here. And we have to find a way to again reiterate the importance of the Fourth Amendment. Unfortunately, through the process of judicial review, our courts have made that exceedingly difficult.
Well, with the snooping programs and whatnot, it's basically, in a nutshell, they're looking for information that is tested against a database or a data bank of certain buzzwords. So if they're snooping through somebody's email, and let's say Randy and I sent each other an email, we were talking about Albert Einstein and his take on the nuclear bomb, or the atomic bomb. That email, every time we would mention the word bomb, it would set off a flag. Or we mentioned plutonium or atomization. So anything pertaining to what they think or view as a national threat, it would be flagged in this database, and then they would take that information and say, well, this now becomes our probable cause. So they're actually trying to create probable cause in order to, in some cases, actually go to a court or to a judge and get a warrant, say, we believe that these emails, to use that example, initiate probable cause, or show that our probable cause is there for us to come to you for a warrant. Judge signs off on it. Next thing you know, our houses are raided, more than likely at any ungodly hour of any day. Our computers are seized. Not just the computer where the email is transmitted from, but all computer devices, all electronic devices, smartphones, iPads, tablets, so on and so forth, even smart TVs, are all seized, quarantined, gone through, and then any other place where we may have put our fingers on a keyboard could also be gone and seized. And this is the kind of dangerous outreach that they have when they want to create something that, because probable cause doesn't exist before this, they're creating the probable cause and then doing it retroactively, ex post facto even, to say, well, now we have the probable cause, so now we can go get the warrant and we can do this the right way. See, the British did the same thing, because what they would do is they would have people spy in taverns, and eavesdrop on conversations, and then they would go and raid all of those individuals' homes based on certain words that they would hear in the conversation, which is taken completely out of context. So it really is no different than what the British Empire did to the colonials and those who came here to get away from that oppression. It's right along the same lines. The only difference is the technology has advanced in such a way to where they could do it more with ease, to where they don't even have to be in the same room. They don't even have to be on the same continent. Hell, for all we know, they may not even have to be on this planet. They could possibly even be on the moon. And I know that sounds conspiratorial, but you see where I'm going with this. Hopefully.
What it shows is that the government is increasingly divorcing itself from the foundational principles that made this country great. We always had these protections because, as George Mason had concluded when he was selected to help draft the Declaration of Rights for the state of Virginia, it shows that we have certain fundamental and unalienable rights which cannot be encroached upon by any legitimate government. But I have to pause there for a moment and provide emphasis for the word legitimate. If the government is attempting to whittle away at our Fourth Amendment protections against unreasonable searches and seizures, then they are actively encroaching upon our fundamental and unalienable rights, which automatically, by its very nature, makes those activities the activities of a rogue or illegitimate government. And yes, what Jeremy was mentioning there was a use of warrants as an ex post facto analysis. But the other problem that we are encountering with this sort of expansive, totalitarian sort of mindset being exhibited by various levels and branches of government is information overload. They have been collecting so much information that they don't even know where to look. If they did, then maybe they could have prevented the Chechnyan Mario brothers, the Tsarnaev brothers, from actively going out during the Boston Marathon and using pressure cookers to create bombs. But they didn't know where to look for that, even when foreign intelligence services had warned them of the potential threat posed by the Chechen Mario brothers, because they, first of all, had bought into this political correct nonsense, and they didn't want to target the Islamic Chechens who had sought asylum in the United States as so-called refugees because they would be mistreated in Russia, or so they claimed, because it wouldn't be politically correct to do so. But they also just had too much information to even narrow down what the suspects might be or who the suspects were. That is a major problem And it shows that this type of totalitarian thinking really does not make us safer. It goes again to that quotation from Benjamin Franklin that both Jeremy and I have frequently paraphrased here on the Wright Flyer, that anyone who would attempt to give up their sacred liberties, their fundamental and unalienable rights for a false sense of security deserve neither, and shall surely have neither. That is what is starting to happen in this country. And it's alarming that we would even have to ask the question of whether someone like an Edward Snowden is a true villain or hero or not. And in fact, that is the story that the mainstream media ran with when this information first broke. What was it? I guess 2 years ago, because they didn't want to focus on the fact that, hey, look, the government really is encroaching upon our fundamental and unalienable rights. They didn't want to make this current administration look bad, again, because of this cancerous doctrine known as political correctness. Political correctness tied in with the efforts by the judiciary and various other governmental agencies to whittle away at the importance of the Fourth Amendment has really led to a cornucopia of problems that is currently facing the decent, hard-working American citizens. But it gets worse, because when you look at some of the other excuses that are being fronted by various law enforcement agencies to skirt around the warrant requirement of the Fourth Amendment, you see that they start saying that it takes too much time. It's too time-consuming. Well, of course it is time-consuming. It is meant to be, because we don't just want the government running out there using their power in an abusive fashion, especially when it comes to our fundamental and unalienable rights, because if we allow that to happen, then we are allowing that which does not have the authority to legitimately and rightfully encroach upon our rights to do so. And our founding fathers would be absolutely appalled and abhorred by what is happening here, because this is the very sort of thing that they were trying to prevent when they included the Fourth Amendment to the Bill of Rights, and of course when that was ratified and became a valid, concrete part of our shared United States Constitution.
You know, what this reminds me of when you talk about the information overload, it reminds me of the movie in the Dark Knight series, the Batman series. You had Batman Begins, and then you had the Dark Knight, and then the Dark Knight Rises. It was actually that second film where Bruce Wayne, or Batman, actually had this giant monitor that was capable of intercepting and tracking every single cell phone conversation within all of Gotham City. And he set that technology up, and Lucius Fox's character said, this is too much power for one person or entity to handle. The intentions behind it were seemingly good in order to track and monitor and catch a sociopath, but at the same time, Batman was willing to forego everybody else's privacy to protect the betterment of the whole. Now, in certain circumstances, I understand that sometimes things need to be done for the betterment of everybody. Okay? Very rare certain circumstances. But it was nullified when, at that point, Batman's character told Lucius Fox, when you're done, enter your name into it as well. It seems to create a vicious cycle. Now, Batman is one of my favorite comic book characters of all time, but I have to say, at that particular instance, I think it was actually showing the dangers of how that kind of technology, that kind of snooping and spying and invasion can be detrimental to everybody. In fact, it would be required of everybody to participate in it when he made that comment to Lucius Fox, when you're done, put your name and number in there as well. So, to draw off of that, it goes to speak of the information overload, because, yeah, even though that technology was able to track and pinpoint and triangulate a certain thing, what happens if there's a flaw in that technology, or there's too much information that gets jumbled together? Now you have the wrong person, and something catastrophic happens. What you were trying to prevent still happens, and yet now somebody else's rights are violated. Many other people's rights are violated. All for what? To have this sense of security for everybody else. Again, I'm going to go back and say that our first line of security against any infringement upon our rights starts with us, the individual. Because we are the first person initiative that when our rights are violated, we're the first ones to know about it. Not the police, not the government, not the courts, we the people. Because it's an effective and absolute instantaneous infringement upon our rights. And if we know our rights, we have a fluent working understanding of how the Constitution is applied, and with what our rights are, where they begin and where they end. Because, folks, let's be clear on this, our rights do end. They end when we exercise our rights to infringe upon the rights of other individuals, and vice versa. Their rights end where ours begin. And to allow that to keep going, and to convolute it all with snooping programs, with invasion for the creation of a sense of security. Again, Benjamin Franklin, it's like he's sitting right next to me, telling me, you're reiterating everything that I've said before.
And it is a major problem when the government will use any excuse to perpetuate this type of system, saying that it is necessary for the national security of the country as a whole. Yet when we really stop back and look at it, what would a program like PRISM really have done to prevent, say, an event like 9/11 from occurring? The fact of the matter is, again, with reference to this information overload, is that it wouldn't have prevented it. There are just too many moving targets and variables for it to have done anything other than to strip the decent, law-abiding American citizen of their fundamental and unalienable rights. And that's part of the problem that we have with any of the modern governmental responses to whatever sort of problem might arise, whether it be terrorism or these dastardly acts of cowards running in and shooting up these gun-free zones. The government's response is always to strip law-abiding, decent, hard-working American citizens of their fundamental and unalienable rights. It is an undeniable pattern that we have seen repeat itself time and again in recent years and decades. And part of what we would see as an excuse or justification for this type of warrantless wiretapping would come from, say, the FISA court, which says that, no, this really doesn't matter or come to the point of a warrant requirement because it isn't really a search, because you have no expectation of privacy in cyberspace. Now, what part of that is that it can't be just expected to be open like that, because a lot of our personal data has been forced to be divulged within cyberspace. All of the electronic health records, or EHR, is required by the government. They have been working to force medical practitioners throughout the country to adopt these programs, and that means that the personal data is put out there. So in other words, the government is acting in a way to once again infringe the language as was contained in the four corners of the preamble to the Bill of Rights, which said that the entire purpose of the Bill of Rights was to prevent the misconstruing of certain fundamental and unalienable rights held by the people to the detriment of their other rights. That explains that the government, in claiming that they don't need these warrants, or that they don't need to provide the American citizens with due process because a foreign entity might be involved, are actually reading this into such a way that it is disparaging the rights of others. In the case of the warrant requirement, it is that they are misreading the language or misinterpreting or extrapolating the language within the Fourth Amendment to once again shirk the requirements of a particularized warrant. And again, the Founding Fathers had included those particularized requirements and prerequisites in order to obtain a lawful, judicially sanctioned warrant to ensure that the fundamental and unalienable rights of the people are protected. Irrespective of the fact that some of the data may have originated in a foreign country, the fact that it traveled through American servers and American citizens' computers demonstrates that, again, they really ought to have to go through the proper warrant process, because let's say that the final data does end up in an American citizen's home, and let's say that this was put on their computer by a malware software, or, one of those spyware programs, then when the police and various other law enforcement agencies break into the house or, use a no-knock warrant, if they even get a warrant, and intrude upon this space based on this preordained sort of probable cause which they gathered through the snooping programs, and arrest him, he has now suffered one of the worst violations of his fundamental and unalienable rights. It is far better that we let some guilty people escape from justice than it is to wrongfully prosecute and punish a truly innocent soul. And that is the same type of philosophy that supported everything that our Founding Fathers did. In fact, it was what proved to be the linchpin of the development of our criminal justice system. Our Founding Fathers inherently understood that if we ever allowed our fundamental and unalienable rights to be infringed upon in such a grievous manner, then we would be allowing the government to reach into the deepest facets of our private day-to-day lives. And of course, that is exactly the type of power that especially this current administration, hungers for, yearns for. They actively seek to gain whatever little foothold they can get to micromanage our day-to-day lives. And again, this only reiterates why we have the warrant requirement within the four corners of the Fourth Amendment. It is to ensure that the thing that we're seeing with this government today was never supposed to happen. But it has happened due to complacency, due to a growing lack of understanding with respect to our fundamental and unalienable rights.
Well, I'm going to take this down to another level, okay? Let's take this down to the level and let's discuss our friends at the TSA. After 9/11, the TSA was created as part of Homeland Security for protection of and monitoring of air traffic control, people, passengers boarding flights, so on and so forth. And when they did this, the TSA has actually gotten out of hand, and we've actually talked about this with, I believe it was South Korean exchange student that was manhandled by some TSA agents. We talked about that on a previous show. Their justification for all of this, and I know that sounds screwy because their justification actually comes straight out of the Constitution, but there's a caveat to it. Let me read you their justification. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. That's the necessary and proper clause of Article 1, Section 8. It's Clause 18. Now, how they twist this and manipulate it and interpret this is they want to attach the general welfare clause to that because they're saying that it's necessary to have agencies like the TSA for strict infringement upon illegal searches and seizures of individuals because it is part of promoting and paying for the general welfare of the United States. See, what they've done there is what's known as a double whammy with interpreting the Constitution. They take one part of the Constitution and interpret it to mean something else so that they can take that other part and throw it out there and use it as a justification to where people will say, oh, well, okay, they're quoting the Constitution, so they must be right on this. Wrong. Because the General Welfare Clause, let's start at the root of it, the General Welfare Clause only pertains to the functionality of the United States government. Meaning them keeping the lights on, paying for our elected officials' salaries, water bills, utilities, basically the operational expenses of the United States. For them to be able to actually have a place like Washington, D.C. to make laws and regulations. What they seem to forget is they seem to omit the word proper out of the necessary and proper clause. They leave it right out because in order for that to be proper, it would have to follow the confines of the United States Constitution the way it was intended and originally drafted and laid out by the Founding Fathers. They have to omit the term proper because it's improper for them to construe any part of the Constitution or interpret any part of it whatsoever. Now, when we get to our friends at the TSA, they say, well, we're a government agency, we're a department. We have the authority to do this under the necessary and proper clause. Again, this creates the notion that people take it at face value and they've become complacent and saying, well, if they're talking about the Constitution and they're citing the Constitution or what they think is the Constitution, what the general public thinks is the Constitution, they're willfully accepting of this because they don't understand the Constitution. Now, dealing with the Fourth Amendment, I know I kind of sidetracked going to Article 1, Section 8, but the purpose for that is, again, because of the preamble. Because of the preamble of the Bill of Rights, the Fourth Amendment carries the full force, weight, and effect of the entire Constitution as the supreme law of the land. Therefore, to interpret any part of the Constitution in order to justify gross negligence and malicious intention with taking any amendment or any other part of the Constitution out of context is a direct violation of the entire Constitution itself under the Supremacy Clause, a violation of the preamble to the Bill of Rights, a violation for each independent article and clause that they interpret and use as justification. It creates a giant web of nothing but malicious intent. And the only way to stop that, and the only way for it to be undone and swept away, is for individuals, again, to emphasize and reiterate this, have a fluent and working understanding of the Constitution, how each amendment coincides with each other, how they coincide with the particular articles of the amendment, all 7 of them, individual clauses of the amendments or the articles, having that fluidity that shows and lays everything out. That is the whole auspice of these programs, folks. It is the entire foundational matter of why we are doing this, so that people can have that fluid and knowledgeable working of the Constitution and the understanding that is entailed with it. Also having the understanding that it's our responsibility to make sure that that is never washed away.
And, what these types of government programs speak to and further demonstrate is a build-off of the lines of court cases that have been decided with respect to the Fourth Amendment. Take, for instance, the notion of a dog, a bomb-sniffing dog or a drug-sniffing dog searching around the premises of a house. Well, the courts have held that that is not a search. Yet, if you really look at it in the context of the way that the Bill of Rights was drafted, that's just attempting to obfuscate the importance that the Founding Fathers had placed upon the issue. Irrespective of the fact of whether a dog sniffing is actually a search or not, the fact that it is prying into or probing into the person, houses, papers, effects, what have you, of that citizen would again speak to the subject matter of the Fourth Amendment. And that is the kind of danger that you run into when you allow courts to extrapolate from the Constitution certain things that are not to be there. It's why in cases like Griswold v. Connecticut, it was so dangerous when Justice Douglas had mentioned the so-called penumbras or shadows of the Constitution. In other words, it means that they were doing the very thing that the Ninth Amendment and the preamble to the Bill of Rights expressly prohibited. They were interpreting the Constitution in such a way as to create something that was never there to begin with. And that is a major danger and something that has happened with respect to a great many of our fundamental and unalienable rights with respect to the Supreme Court. For instance, while it's not directly dealing with the Fourth Amendment, the idea that there could be so-called common sense restrictions, as Justice Scalia had mentioned after the Heller case, that opens the door for this type of limiting or expansion of our fundamental and unalienable rights, which, as we have previously stated, is constitutionally prohibited. And that, too, is a major problem, that these courts are engaging in constitutionally prohibited behaviors. This is what is known as extra-constitutional behavior. It is attempting to devise something from something else in a way which does not make sense either logically and is actually violative and contrary to the exact language contained within the four corners of the United States Constitution itself. And as Jeremy and I have frequently reiterated on this show time and again, that Article 6, Clause 2, strictly states that the United States Constitution is the supreme law of the land. Therefore, any of those types of excursions away from or distancing from the United States Constitution actually serves to violate the supreme law of the land, because the Constitution is the supreme law of the land. But it gets worse than that. This idea that they can use aircraft with heat-penetrating or heat-registering radar to gaze into the interior of a house without securing a warrant, the fact that they can use satellites to gain information and to look in upon someone's property without a warrant, these are all dangerous areas which the law has not expressly addressed that should raise the ire in any decent, hard-working American citizen. But what we really know, and what the exposure of programs like PRISM and the nefarious activities of the National Security Agency, or NSA, or yes, even the way that the TSA can go around our fundamental and unalienable rights, we have seen an established pattern by these governmental agencies and bodies to actively lie about what their intent is, to go further than what they are claiming, and all for made-up reasons that just don't logically come to fruition or make sense. And therefore, this attitude on the part of the government proves that they are not truly or necessarily working in the best interests of the American citizenry. And that should not happen, because another thing that Jeremy and I have often reiterated here on previous episodes of the Wright Flyer is that due to the natural law principles, that is, the natural order in which our government operates and was established to operate as, we, the people, are the absolute and supreme sovereigns. We have delegated certain powers and authorities both to the governments of the several states via the state constitutions, and then the state governments, in their representative capacity, again delegated a number of governing authorities and powers to the United States government via that wonderful contractual document that is owned and shared by us all, the United States Constitution. And therefore, the federal government is supposed to trace any and all of its governing authority back to a power that is specifically enumerated to it. But when you see that they dig for rights that aren't there, or for powers that aren't there, these so-called penumbras, you really do have a danger, because they are acting way outside the scope of how this government was intended to act, and we suffer the detrimental consequences they're from.
Well, what this also does, it actually allows other legislative acts, no matter what they may be, to come into fruition, into existence, because they piggyback off of these excursions, these penumbras. Prime example would be Obamacare. Now, Obamacare, it violates the Constitution in so many ways that we don't have time for this flight to actually mention and delve into. So we'll start with the basics. And all of these are done by proxy, okay? When you have a ruling like Obamacare, which was basically nothing more than Justice Roberts formulating his opinion by way of rewriting the legislation, again, because it's necessary and proper, so to speak, as they would say, you create an automatic violation of the Constitution, which first and foremost would be it establishes that law as a bill of attainder, which is nothing more than a penalty levied against a named or ascertained named group of individuals, where they suffer a penalty without judicial proceedings, i.e. no due process, which automatically violates the Fifth Amendment by proxy, which in turn, because it violates the Fifth Amendment, there is no foundational building block whatsoever for the Fourth Amendment to even come into play. It's just thrown right out the window. In fact, the IRS, the way they're going to levy the penalty is, you do your taxes. If you're expecting a refund, you don't have health insurance, the refund comes right off the top. So where's the warrant issued to seize that money, which is your property? It's your property. It's an illegal seizure of your property. For them to even ask the question, do you have health insurance? Or have you had health insurance for X number of months out of the year, is an invasion of privacy. It's none of their business. Why? Because health insurance cannot be mandated. It is a commodity. For them to mandate health insurance would be to the likes of them mandating the type of vehicle you have to drive or the type of television you have to buy in order to receive broadcasting. When you go to the great lengths to do that, you're now bringing into question the validity of their actions, and also it establishes the direct violations, which should be known, again, through having a fluent and working and knowledgeable understanding of the Constitution and your rights, to see that just asking that simple question. Another scenario, another case, the census, our centennial census. Every 10 years we fill out a census. Okay, there are questions pertaining to that census: ages of the individuals in your home, the race of individuals in your home, the ethnicity, how many bedrooms, so on. That is all illegal searching, is what it is. The only thing that they need to know on there is the number of individuals living in your home. That's it. Has nothing to do with how many bedrooms your home has, how many square footage it has, the ethnic makeup of the individuals in your home. None of that applies. It's none of their business. Because it's none of their business, they want to know. Because they want to know, they want to infringe upon your rights by illegally searching for that information. Again, if you willfully give that information to them, whether it's answering a question on your tax forms, checking the box yes or no whether or not you have insurance, you're willfully giving that up. You are forfeiting that right. Now, here's the caveat to that. If you don't answer those questions, now you're penalized you're actually facing charges under penalty of perjury and falsification of federal documents. That's how they seal it up and entrap everybody. Again, violation of your Fourth Amendment, because now you are not secure in your person or your papers, i.e. your tax forms, because you are forced to answer up to something that you should not have to answer to, which again reverts right back to the Fifth Amendment, self-incrimination. This is an ongoing problem, and what we need to do is figure out a solution. And most assuredly, we will have another flight dealing with solutions pertaining to issues like this. Can't tell you when. Not sure when the manifest on that is going to be produced. Not sure how much TSA is going to have a problem with it, but who cares? Fact of the matter is, we have to come up with solutions for this. We here at the Wright Flyer are driven by bringing you the information, bringing you the issues, and offering viable solutions to them. And as I stated before, as well as Randy did, as far as we can tell, the most viable solution that will present other solutions for other problems is strict adherence to having a fluent and understanding working of the United States Constitution. That's where we have to begin.
And that is, of course, why we always do and provide this service to you. As I have frequently reiterated, and Jeremy has frequently reiterated as well, the most important service that we can render to you, our listening audience and passengers, is to provide you with the building blocks to secure this fluent and knowledgeable understanding of the United States Constitution. And we say that it is fluent and working for the knowledge and understanding of the United States Constitution because there is no way that any individual can learn and know everything there is to know about the Constitution. That is because while the principles and edicts and the foundational aspect of the United States Constitution is set in stone, our lives are transitory, and therefore certain aspects of a modern life, say like with the development of technology, occurs in such a way that the Constitution has to be applied to it. But because the principles of the United States Constitution are so timeless, it can incorporate into the changing aspects of our lives, but we, having not been exposed to that or having seen that yet, may not know how that works. And that is why we say that it is nearly and actually is impossible for one individual to know everything that there is to know about the United States Constitution. Going back to one of the things that Jeremy had said with respect to this issue, especially with respect to the United States Census, the idea that they are saying that they can pry into your house doing these unreasonable searches and seizures without actually going through the proper warrant process is they are trying to say that that information really isn't private because you can't have an expectation of privacy within it. Again, this is the sort of danger that we run into when we allow the court systems to engage in this judicial review power that they essentially granted unto themselves. Because if you ever attempt to look for the power of judicial review within the four corners of the United States Constitution itself, you simply won't find it, because it is not there. It is not a part of the United States Constitution. Rather, it was the court or the judiciary acting in an extra-constitutional manner in the 1803 case of Marbury versus Madison, then later with Fletcher v. Peck, Martin v. Hunter's lessee. The list goes on and on ad infinitum. But what it demonstrates is that when the government acts in such a way as to give power unto itself outside of the actual basis and four corners of our shared United States Constitution, we suffer the detrimental consequences as a result. They steadily march on and on and on in an attempt to garner ever greater power, amassing it illicitly for themselves at the expense of the true sovereigns of this great republic, that being we, the people of the United States, and they act with flagrant disregard to that fact. In fact, at every step of the way, organizations like the TSA and organizations like the NSA or the FBI or the CIA, the way that they have been acting as of late is in complete contempt towards the people. They automatically assume that we are guilty. They automatically assume that we are somehow diametrically opposed to everything that they are doing. But it is not we, the people, that have set it up that way. It is they, these governmental actors, these nameless, faceless, and ultimately unaccountable governmental bureaucrats that have created this contentious atmosphere, this adversarial component to our fundamental and unalienable rights that's not supposed to exist. It is because they have essentially become the agent provocateurs and the champions for the tyrannical and despotic causes that our founding fathers fought tooth and nail against to ensure that it would never arise here in the United States. But, as Jeremy had mentioned, and as I have said, because of this making it so difficult just to even simply survive in the United States, it has bred this sort of complacency that has allowed the government to get this sort of foothold within society, and they are tearing apart the United States Constitution at the seams. And again, this can be seen in this notion that they don't want to have to get a warrant to search for whatever evidence that they need to obtain or to actually arrest someone. And you can see this in the way that they want to gain information from smartphones without having to use a warrant. In fact, they've even had special devices, I believe they are called Stinger devices, which go in and can pry out information from your smartphones or whatever other mobile electronic technology you might have on your person to gain whatever information they have within it. And they can say that they need that information to, let's say that they believe or suspect that you are involved in some sort of criminal conspiracy, and they want to find evidence that it's connected to someone else. They can try and pry into that with these devices that I mentioned a little bit earlier to gain that information without having to go through the warrant process. Again, why? Because they want to be able to do it without having to go through the judicial hurdles, which they claim would put the criminal conspirators or co-conspirators on notice. But the fact of the matter is that really is irrelevant when it comes to our fundamental and unalienable rights. Because once they have that excuse, once you allow them one excuse, they're going to keep coming back to the table asking for more and more and more without stop and without hesitation, because what they really want is absolute and total power. Because it's, as Jeremy has frequently mentioned, that old adage that power corrupts and absolute power corrupts absolutely, they are wanting to allow themselves to have all of this greater power to themselves, because then they don't have to work as hard, or at least in their mind they are perceiving that they don't have to work as hard. But the truth of the matter is, when they act in such an arbitrary and capricious manner, they are actually making the government a rogue and illegitimate government. And that is not something we can afford here in the United States. But when you couple that with nefarious actors, with those who are intentionally and deliberately attempting to strip away our fundamental and unalienable rights, such as President Obama, who's come out and said that, back when he was running for office the first time, that it was his goal to fundamentally transform the United States of America, well, this is part and parcel of what he was speaking. This idea that the census should be utilized in such a way as to engage an unreasonable search for information to then push these sorts of government programs where, let's say, they are asking about the racial makeup of the families within the house to create a government housing requirement that there is not enough diversity within that neighborhood, and therefore we're going to require that, say, a certain number of Section 8 housing be built in the area, thereby driving down home values. That is actually acting in a way that the government is not supposed to be able to act, but it is something that this current administration, especially under this administration, has been working towards. They have been working towards stripping us of our fundamental and unalienable rights.
Well, with speaking to the census, and I'll just say this, another tentacle of that would be, like you mentioned, the diversity, and for the housing projects and so on and so forth. That also plays into districting or redistricting in order to shift the number of votes in their favor. Supreme manipulation in order to gain an even stronger foothold within our halls of Congress, or even at the state level. See, part of this reason that we've seen this is, let's look at the last presidential election results. I believe it was one district in Pennsylvania where Obama got 110% of the votes. Now, how is that possible? Now, let's remember, the presidential election was in 2012. The census took place in 2010. Is it possible that that census was utilized in order to stack the district with votes to create voter fraud in order for Obama to garner more votes than his opponent? Very plausible. The other issue with this, and I want to divert this to Randy because he has a better understanding of history than I do regarding such things. But I'm going to bring up two instances where, again, utilizing illegal searches has caused drastic things to happen within our own government and our own elected officials. And I'm talking about the Alien Sedition Acts and also the instance where Abraham Lincoln had, I believe his name was John Vallandigham, arrested right in the House, right in the House of Representatives, and removed from his seat and deported out of the Union States simply for calling Lincoln a tyrant. Now, just because he spoke these things and said these things, there was no legitimate warrants for him to do that. As speaking of Lincoln, there was no legal Fourth Amendment procedure whatsoever. It was done as a knee-jerk reaction because there was an offense taken to what was said. This is a very dangerous and very slippery slope if we allow things like that to happen, because what is stopping a local municipality, county government, state government, or even the federal government for simply going and arresting an individual just on the basis of what was said or heard? There's no probable cause. There's no oath or affirmation taken in an affidavit in order to issue that warrant for arrest. We find ourselves slipping down that slope, and people legitimately, American citizens legitimately afraid. They have become complacent so much and afraid because the government has acted in this fashion, and they've made examples out of individuals to say, you're not going to speak out against us, because if you do, this is what's going to happen. A complete devastation of the Fourth Amendment ever even coming into play. It's just not even allowed to come into play, which automatically, again, is a direct infringement by proxy of the Fifth Amendment, the Sixth Amendment, the Ninth Amendment, the 10th Amendment, your First Amendment rights, so on and so forth. When we continue, if we allow that to happen to our Constitution, ours, again, it goes without saying, and it has to be mentioned every opportunity that it can, that this Constitution is ordained by we the people. It is ours. We set it forth through our representatives to where they wrote it for the behest of us, for the understanding that we the people are the true, as Randy says, individual sovereigns. We delegate the authority to them. This is why the Constitution is written in such a way, because it was written that founding fathers knew, they knew that in order for a government to not become tyrannical or despotic, that checks and balances have to be placed on them. And those checks and balances are our authority that we have, that we exercise, that we allow them or delegate to them in small parcels to govern over us. If we do not take hold of that and re-embrace it, we're surely going to lose it all.
Right. And again, what you can see with the Alien Sedition Act, which was created by the John Adams administration, which happened to be the second presidential administration of the United States, was that they feared that there would be a war with the French. That's why it had the term sedition within the proper name of the act. The Alien Sedition Act was designed to supposedly protect national security interests in the fledgling nation to prevent a war with the French. And therefore, what they were trying to do was to discourage anyone from actively speaking out against the government, because they were afraid that these people might be alien actors or outside actors or foreign spies. And it just goes to show kind of the overarching mindset that even that early on in our government's history, the government had taken this approach of distrust to the true holders of sovereignty, the people. And, of course, the Alien Sedition Act was one of the greatest epicenters or fulcrums used to spring the Federalist Party out of the annals of power and propelled the third president, Thomas Jefferson, and his fledgling Democratic-Republican Party into office. Now, don't get confused by those names. They don't reflect the modern Democrats or Republicans. It was the first instant of that being seen in the country, Democratic Republicans, but it was a totally different party than the modern and separate iterations of that name. Now, moving on to what Lincoln had done, it wasn't just the individual that was pushed out of the Union for stating that Lincoln was a tyrant. the president had also thought about arresting the Chief Justice of the United States Supreme Court, Justice Taney, for speaking out against Lincoln's suppression or removal or withdrawal of the writ of habeas corpus and his marching into the so-called border states of Kentucky and Missouri to arrest those who might actually vote in favor of secession. And he also did this in Maryland, preventing them from having a vote on what most at that time had considered a lawful and constitutionally permissible action, that of removing from the Union, because the Union was viewed as a voluntary agreement. That was because the United States Constitution was also viewed as a contractual document. It was a social contract between the citizens of the United States and the federal government. And then when we say that these powers that have been given to the federal government were delegated to them, of course, the natural law would say that that delegated power can also be taken away whenever the United States government, or any government for that matter, acts against the terms of the natural law document. In other words, again, speaking to Article 6, Clause 2 of the United States Constitution, that being the Supremacy Clause, whenever the government acts in a way that is contrary to the natural law document being our shared United States Constitution, they are acting in an illicit or malfeasant manner. And therefore, whatever actions that they have taken, like Lincoln wanting to throw people out of the country for calling him a tyrant, or preventing those states or various other territories from deciding their own fate, was actually outside of what the Constitution was and represented and stood for. And it shows that these tyrants loathe the fact that the United States Constitution is a document based on the natural law tenets and principles of it all. But it also shows that going back to basically the inception of this great republic of ours, they have used the national security type of argument to steadily march against and encroach upon our fundamental and unalienable rights. And that is certainly something that has not changed even today.
Well, again, I'm going to bring up this fact that it could all be used as incremental propaganda, because the whole auspice behind this is to breed complacency. When you breed complacency, automatically there's an element of fear that is put in place and is set. Again, individuals are afraid to speak out against their rights being violated. They're afraid because they've been made complacent, and the complacency comes with them not having a working and fluent understanding of the Constitution. Let's face it, when I was in school, in grade school, and in junior high and high school, it seemed that the longer I went to school, and the higher I got up in the educational system, the less and less that the Constitution was spoke about. We mentioned, the Bill of Rights, the preamble to the Constitution, so on and so forth, and that was it. They were never explained. There was a brief summary given, but there was no explanation. You see, it would be akin to an individual buying a home theater system and a technician just giving them a summary of how it works and how to set it up. But the system never operates properly for that individual because the technician fails to explain it. The technician being the educator, so to speak. Or even if there's no technician present, the directions that come with the home stereo system. See, you could view our constitutional representative republic as that home theater system. And the instructions on how it's supposed to work is in fact the United States Constitution. And the explanation of those instructions could be viewed as the Federalist Papers, the Anti-Federalist Papers, any and all writings by the Founding Fathers. You can even look to state declarations, such as the Virginia State Declaration of Rights, written by Thomas Jefferson and George Mason. You can look to writings such as Common Sense by Thomas Paine. Some people would even try to bring in foreign documents like the law by Frederick Bastiat, which really is nothing more than a theory, which some points are true and valid. However, I would refer to that as, the Greek or Hispanic or Spanish or maybe Chinese section of those directions. You may be able to make out a couple of words here and there, but it doesn't really give you the full gist of the functionality of that entertainment system being our constitutional representative republic. It's only when we take the time to sit down and read those instructions, and if there's any discrepancies on those instructions, to search deeper as to, okay, what does this piece mean? What does this piece mean? Because of our technology we have today, we can actually look up online instructions and actually get a more involved, more in-depth explanation of said instructions. This is what we encourage individuals to do. Those set of instructions being the Constitution, the Fourth Amendment, Fifth Amendment, the Constitution in its entirety, how it relates with each other, individual pieces of that entertainment system that needs to be put together, how they work with each other, why Part A goes with Part B, why the preamble of the Constitution establishes that we the people ordain this to ourselves and our posterity. That means it's perpetual until we are no longer, as a nation, a constitutional representative republic, able to produce offspring. This Constitution, the social contract, is perpetual, unending, never ending, until that point. Part A, preamble, correlation to Part B, the 7 articles of the United States Constitution, and how Part A and Part B collectively together are supported by Part C, the preamble to the Bill of Rights. And then, of course, you have the Bill of Rights and every amendment ratified after that as the remaining parts of the Constitution, all working in concert with each other, working to support and connect with each other in order to have a fluent, working, and viable entertainment system, i.e. a constitutional representative republic. And the tools and the means and the glue that holds all of that together, again, is we the people. We own that proverbial entertainment center. We own that set of instructions. That is ours. It cannot, will not be taken from us.
And that's the thing. The reason that Jeremy and I do these programs is to provide you with this fluent, working knowledge and understanding of our shared Constitution, and thereby your fundamental and unalienable rights. Because everywhere you turn in this modern society, you find a government that is proactively working against your fundamental and unalienable rights. Every problem that we are seeing occur within this country can be directly tied back to some government agency or bureaucracy working in a diametrically opposed fashion to yours, Jeremy's, and my fundamental and unalienable rights. And the only way that we are ever going to be able to stand up to them and proactively tell them that no, they cannot take our fundamental and unalienable rights is to actually know what our fundamental and unalienable rights are, to understand our Constitution to the best of our ability to ensure that we protect it. You know, it's funny. You see and hear our supposed and so-called governmental representatives taking an oath of office, swearing and affirming to uphold the United States Constitution and to defend it against enemies both foreign and domestic, yet when it actually comes down to it, many of these governmental actors and agents are derelict in their duty. They are not doing what is necessary to defend and protect the Constitution, and because they couch a lot of their nefarious and illicit deeds in constitutional-sounding language, they are able to convince a great many of the people that what they are doing is within lines of the Constitution and is thereby permissible. Nevertheless, actually what they are doing is stepping outside the proper aspect, scope, and application, as well as limitations placed on the federal government by the United States Constitution. They are acting in the tyrannical and despotic manner in which our founding fathers feared that any type of centralized government would eventually act or become. And that is why it is so important that you actually go out and read up on the Constitution, brush up on it, sharpen your knowledge of it, listen to what we're saying, but also take the proactive step to engage others with it. You know, Obama came out and said that he wanted all of his supporters and followers to go out and quote-unquote get into the face of those who disagree with him. We don't ask that you get in the face of anyone. What we ask is that you discuss the United States Constitution with them, show them the true logic and reasoning that underpins the longest contiguous constitutional document in the history of the world. If we explain that to these people, if we go into these details, if we truly lead them to the source of knowledge and the source of greatness that made and propelled the United States to such lofty heights in our, let's face it, relatively short history of just over 2 centuries, it's the United States Constitution. Everything roots back to it, whether it be the economy, whether it be the state of our health system. Everything ties back to the Constitution, and the fact that we are encountering rather drastic and significant problems here in the United States today almost always, in each and every instance, can be traced back to the government somehow distancing or divorcing itself from the proper scope and tenets of our United States Constitution, and it is high time for that to stop. Now, with that being said, it is now time for us to begin our descent. So, ladies and gentlemen, I'm going to send the flight attendant back for one last round of alcohol. Sit back, enjoy yourselves, put the tray tables back up in their proper position. I, once again, am Randy Wright, your captain, and joining me is, of course, Jeremy, my first officer. Go ahead, Jeremy.
I just want to add one more thing in regards to individuals and our listeners being proactive. If you're looking for a forum to where you can discuss this, you can find us on Facebook at the Wright Flyer, Radio Aviation Excellence. You can comment on this show and many other shows that we have. Engage with each other, discuss these things. It would be heartwarming to see that. It would be welcomed to see our passengers and our listeners engaging with others, bringing this, sharing it with other individuals, so on and so forth. And now, since Helga's bumped me in the elbow with the drink table or the drink tray, I'm going to go ahead and turn it over to her and let her get to her duties.
Once again, ladies and gentlemen, we appreciate you joining us on these flights. We do this for you. You make this all worthwhile, and we appreciate it. And we look forward to seeing you on the next flight. Thank you again for choosing to fly the Wright Flyer. We're taking it home.